Welcome and thank you for standing by. At this time, all participants are in a listen-only mode. During the question-and-answer session, please press star 1 on your touch-tone phone. Today's call is being recorded. If you have any objections, you may disconnect at this time. I would now like to turn the meeting over to Mr. Matthew Sullivan from International Trade Administration. You may begin.
Thank you, Barbara. Just want to thank everyone for staying on the line. We apologize for some of the delays. We just had some technical difficulties, but thank you for joining us this afternoon for the Department of Commerce China IPR webinar series. Our speaker today will be Alex Koff, a partner and the chair of international practice at Whiteford Taylor Preston in Baltimore. Alex will speak today about the state of IPR protection for environmental technologies, companies in China, and strategies companies in that industry can take to protect their IPR. With that, I'll turn it over to Alex and thank him for joining today. Thank you.
Hi, thanks, Matt. This is Alex Koff. As Matt said, I'm a partner and attorney at Whiteford, Taylor, and Preston. We have 8 offices in the United States and some alliances worldwide. My email is akoff, 2 F's in Frank, at wtplaw.com, and my U.S. mobile is 202-262-1197. Thanks for staying online despite the technical difficulties. What we will do is we have a number of slides here. We're going to break up the presentation into 4 discrete parts. The first part is an overview of the U.S.-China relationship, and I'm going to flip to slide 1 so you can see the outline. Part 2 is a discussion of the rise of environmental and clean technologies. Part 3 is a discussion of Chinese imports into the United States and options to protect your business, so it's a flow from China to the United States. And the third is protecting your IP in China. If you've decided to make the jump into the Chinese market, what can you do to protect yourself, and what are some ideas in advance as well as when you're there? And then I'll conclude with a couple of suggestions. And in general, slides 0 to 24 are dealing with the China, overall U.S.-China relationship. 24 to 40 are talking about the rise in environmental and clean tech. 41 to 50 are dealing with trade remedies, and 51 to 63 are dealing with some direct IP considerations. So in total, 41 to 63 is that part 3. Part 4 is 65 to 80, and conclusions are at page 81. Contact information is the last slide at page 82. I'm going to also watch the time. If you have questions, please, by all means, send them through, and we can try and stop and get them. The slide that you're now looking at, slide 3, the U.S.-China relationship, many of these issues are not new. Xenophobia, fear of China, is a big issue, the theme. I'm going to move quickly through a lot of these slides as backgrounder for you. The economy really is number 1 in jobs focus, and assessment and recommendations are what we're going to look at. But the idea is really the presidential elections coming up in November 2012 is really going to shape our entire U.S.-China relationship, I think. And to understand where we're going to go forward in U.S. policy, I think we need to know where we've been. And what we're going to do now is look at some particular slides that I wanted to point out to you the key focus. For instance, I don't have a pointer, so I don't think you can see what I'm looking at, but on the Committee on Finance page on this slide, Max Baucus is the ranking member on the Committee on Finance, and here he was talking about trading rights, distribution rights, services. These things are quite important to him, and later he was quite effective at instituting a change to trade adjustment assistance. If you can see at the bottom the note, 19 U.S.C. 2272. If there's an issue that's of importance to a particular powerful member on the Senate Finance Committee like Max Baucus is, it's something that will be recurring and likely will be going forward. Successful U.S. policy, I would suspect. China trade history deficit. If you look at this slide, and I'm going back here to the history, 2005, Senators Dorgan and Clinton, Senator Clinton at the time, they introduced measures to cap the trade deficit at 5%. Third bullet on there talks about the companion bill introduced by, at that time, House Representative Benjamin Cardin from Maryland. Benjamin Cardin is now a U.S. Senator, and Senator Clinton is now the Secretary of State. They were both interested in the trade deficit issue, and I think they're watching it closely. I think U.S. policy is also something to watch on trade deficit issues. The next slide deals with CNOOC, China's National Offshore Oil Corporation. for those who remember, there was a big upheaval and upswell against China buying U.S. ports. There was something called CFIUS review, which is the Committee on Foreign Investment in the United States, and even President Clinton was involved in looking at the CNOOC issue. Energy, oil, clean tech, hot-button issues when it comes to China, at least historically. And the next slide deals with U.S.-China relations, and it's a slide that lists Foreign Affairs magazine and some of the titles in the run-up to the election when President Obama was running in 2007-2008. He wrote an article called Renewing American Leadership in July and August of 2007. It had nothing to do with economics. It was mostly the war in Iraq and in the Middle East. But the titles in 2008, in the actual year of the election, I took some of those titles. They are Changing China, China, and Is America in Decline, and then Handling the Economic Challenge from China. So the issues all dealt with China and where China is going to India and Africa. And nestled within there, there's a question, is America in decline? It was at the forefront, I think, back then, and even more so in this election today. Obama in trade policy, he gets elected. One of the first visits he makes is to Canada, and he had a conversation there in Canada with Prime Minister Stephen Harper, and this was in February of 2009. He talked about NAFTA, NAFTA being different than China, and saying that the NAFTA relationship has to be important. But again, China was put off to a different category. The next slide deals with protectionist sentiments, and this is again 4 years ago, and it's looking at steel issues and steel makers. And if you look at this slide from the Wall Street Journal, it talks about how there's a raft of steel trade remedy cases which are coming in, and there was a lot of China bashing going on at that time. Protectionism by America issues, China currency practice. If you remember, in February of 2005, Senator Schumer, again a very strong, important senator, he was very key and big on the Democratic side for the Senatorial Campaign Committee for the Democrats. He introduced a bill, a bipartisan bill with Senator Graham, allowing for U.S.-China currency revaluation and imposition of 27.5% tariffs. This was in February of 2005 because the Bush administration had not gone forward to try and change Chinese policies as it dealt with those issues. And all this will be quite relevant when it deals with the IP focus. And I know that those companies that are here will wonder, why am I getting this education on China? I think it's going to be important background to understand, if you're there, how your business may be affected. Some other major issues which we touched on, consumer product safety. If you remember, Mattel had a big problem with toys and a massive recall. And then I wanted to talk a little bit about the State of the Union address and jobs and exports. The President in January 2010, when he was announcing the NEI, the National Export Initiative, which is now about 2 years into it, said jobs must be our #1 focus in 2010. And he said we need to double our exports over the next 5 years. And then he also mentioned clean energy a number of times in that same speech. He said we can put Americans to work today building infrastructure of tomorrow. There's no reason Europe or China should have the fastest trains or new factories for clean energy products. He said China is not waiting to revamp its economy. They're making serious investments in clean energy because they want those jobs. And he was looking clearly to try and put Americans to work building clean energy facilities. And he said it's time to finally slash the tax breaks for companies that ship our jobs overseas and give those breaks instead to those that create jobs right here in America. So this was from January 27, 2010, 2 years ago. And if you look and understand the way Washington works and the way the power players are working, again, this is Max Baucus, that chairman of the Finance Committee. He held a hearing, and he said this is on March 3rd, he said our most urgent economic goal must be to create jobs. Echoing what the President said, we must do everything possible to open markets and promote our exports. And he proposed a 5-step plan. First was export promotion, trade agreements, key markets, and he wanted to expect more calls on access in China and so forth. The trade balance is something that I think people are looking at as well. And if you look at the trade balance on this particular slide, for those who aren't on audio only, there's a trade balance here that shows China versus the overall U.S. trade balance. And I've just inserted a line which shows that generally the U.S. trade balance with China, not being seasonally adjusted, is flat. but the overall U.S. trade balance has decreased since July of 2008 compared to today. And a lawyer or someone looking at this from a policy perspective may say, well, China, the U.S. trade balance with China has become a larger proportion of the overall trade balance. And they could say that the U.S. needs to fix that when it comes to China. Jobs and trade is squarely on everyone's mind, and it's hard to exaggerate how bad the job market is. I gave a couple of quotes, once from the Wall Street Journal that says 1 out of every 5 men 25 to 54 isn't working, and this is across all the major U.S. papers. The Washington Post said, well, who's going to double their imports? It's just not clear. And the New York Times said at that time, many of the jobs lost during the recession are just not coming back, period. Well, where are the jobs right now? In May of 2011, a year after this, we still had 9% unemployment, and this was looking at the U.S. jobs rate coming out from the Bureau of Labor Statistics. And 1 year later, you guessed it, that's still squarely centered. Unemployment rate remained unchanged 1 year after that at 9.2%. No U.S. president has won re-election with over 9% unemployment, so that's a big magic number that people are looking at. Flash forward to just this past week, March 9th, the unemployment rate remained unchanged from February, but it had dipped, and now it's at a historically high 8.3%, but with more than 12.8 million people out of work. But it's lower and it's dipped below that 9%, so things are improving, but it's still squarely in front of where people are supposed to be. The slide, for those on audio, has a picture of a large horse and a small horse, and the slide says global economy then and now. And at the top it says different beds, same dream. That's a play on a Chinese phrase that says different dreams, same bed, between a husband and wife who may be together but have different views on the world. Here, what the slide is meant to show is that we're all in it together, and China and the United States really need each other to move forward. And now we're going to talk a little bit more about the rise of environmental technologies, now that you have a background to the U.S. overall China relationship. In the rise of the U.S. relationship in clean tech, when Senator Clinton, who then became Secretary of State Clinton, went to China for the first time, she said in February of 2009, President Obama hopes to make climate change the centerpiece of a broader, more vigorous engagement with China, and she said the opportunities in China are unmatched anywhere in the world. And she invited China to join the United States as she toured energy-efficient power plants in Beijing and gas-powered fire plants that sold GE turbines, which she said were nearly twice as efficient as coal-fired plants. Now, take this, and what I wanted to do is show you how the U.S. policy perspective works directly with how your business can flourish. I'll have some slides, and I'll run through them quickly given the time, on smart grid technology. Smart grid, in a place called the Tres Amigas project, for those who may not know about it, is the electricity transmission project that's a powerful substation connecting the eastern, western, and Texas grids in the United States. And there was a discussion about whether cold cables that are produced by American Superconductor could help in that transmission line. There was a bill introduced by House Majority Leader Steny Hoyer, who's also from Maryland, that was going to authorize federal government funding to cover half the cost of the high-voltage transmission projects. Cold cables move large amounts of electricity in a small space. They do it with low-resistance wire through pipes that are chilled with liquid nitrogen that brings the temperature down to minus 321 degrees Fahrenheit. So it provides a more slippery medium for moving electricity than conventional copper or aluminum wire, whose efficiency degrades as they heat up. But the problem is it's quite expensive to move it, and as the liquefied gas cools, it requires pumps and refrigeration units every so mile to keep them efficient. Well, if you look at who produces this, American Semiconductor, they also have international locations, Korea, India, and Beijing, as well as some other places. And now, if you look at it over time, overlaying what we said in the first section to what we have here today, you have a timeline. From February 1st, 2009, Secretary of Clinton goes to China and says that climate change is going to be the centerpiece of a vigorous engagement with China. On the 12th of May, 2009, Steny Hoyer introduces the clean energy bills. On 13th of October, 2009, there's a number of articles that come out in the popular press talking about the Tres Amigas project and asking, is this the future of clean energy? In January of 2010, the President issues his State of the Union speech saying that he's not going to cede the clean energy sector to these other nations. And then in March of 2010, you have Senator Max Baucus talking about the Senate hearings regarding the President's trade agenda. What I'm trying to say here is there's a number of ways to read the tea leaves, and you can understand what's going to happen in the future by looking at what happened in the past. So March 3rd of 2010, at the same time that Senator Max Baucus talked about his trade agenda mirroring what the President said, there was a bill introduced by Senator Schumer, that strong, powerful Democrat, talking about the limiting of ERA funds, the American Recovery and Reinvestment Act of 2009 funds, because he said that reportedly of the 80% of the $2 billion stimulus in renewable energy grants, they were all awarded to foreign companies. 80% of that stimulus was awarded to foreign companies. And he singled out the U.S. consortium with Chinese consortium to build a 648 megawatt wind farm in Texas for $500 million. This was participation of China's Shenyang Power Group. It was highlighted on Capitol Hill, where you have the folks on Capitol Hill saying, if we have energy projects, why aren't we really giving these stimulus funds to American companies as opposed to Chinese companies? Well, let's go forward. Today, in March 6th of this particular year, CNOOC is back, and Sinopec is back. Remember, CNOOC had created a lot of bluster in 2005, and their deal was turned away. Well, just this past week in the Wall Street Journal, it was reported that since 2010, Chinese companies have invested more than $17 billion with a B into oil and gas deals in the U.S. and Canada. And recent investments have been positioned intentionally as, quote-unquote, non-threatening to get back into America. And this is according to the CEO of Chesapeake Energy. How? The Chinese have sought minority stakes, played a passive role, and in a nod to U.S. regulators, kept Chinese personnel at arm's length from advanced U.S. technology, which moves into the IP space. Fu Chengyu has been leading this push, and he was the chairman of CNOOC and learned his lessons in 2005, and now he's the chairman of Sinopec, another large state-owned energy-related company. You also have other Chinese companies like BYD, which is a name that now people sort of call it build your dreams. They want to be the largest Chinese automaker by 2015 and the world's largest automaker by 2025. They were able to jumpstart their production, and the company never existed, I think, before maybe 96. They got their start making cell phone batteries for Motorola cell phones in Shenzhen, China. And from there, they got their jump start because they made batteries for cars and a new way to go forward with electric cars. So this is a new way that China's moving forward. And flash forward to our own State of the Union address with President Obama saying, I will not cede the wind or solar or battery industry to China or Germany because we refuse to make the same commitment here. And he's tried to back that up, it seems, with things like ARPA-E. ARPA-E is the Advanced Research Projects Agency dealing with energy. It's housed within the Department of Energy, and it funds the development of transformational and disruptive energy technologies and systems. They want to find the new thing, and it focuses on high-risk concepts with high rewards. And by law, ARPA-E is required to spend at least 5% of its appropriated funds on technology transfer and outreach activities. It is looking like clean energy is becoming a national security issue, and as things are heightening with the U.S.-China overall relationship, and clean tech being that next focus and really where America has its drive, it's looking like energy is going to be that next real strong focus. There was a publication in the Federal Register that came out today, March 13th, that talked about a federal interest in environmental technologies. It says the U.S. is pushing in trade in environmental technologies. And the notice set forth the schedule and proposed agenda for a meeting of the Environmental Technologies Trade Advisory Committee called the ETTAC. And that's going to be scheduled on Thursday, April 27th, 2012, 9 a.m. Eastern time in Washington. It's going to talk about globalizing global environmental regulations, issues related to innovation, trade liberalization negotiations, and it's something to be aware of if you're trying to take advantage of clean tech and United States technologies. But the United States isn't the only one to deal with this. I put together a list of certain technologies that at least our law firm has been involved with. Just to give you a sampling, U.S. technologies that have gone from here to the world: sludge to oil technologies in Brazil, floating wetland technologies in Canada, technologies coming from the world to the United States. We've been involved with ocean and wave to air energy technologies that came over from Ireland and Scotland and been employed here in Maryland and along the eastern seaboard. And there's also been Chinese technologies that have gone out to the world, like vacuum tube solar technology, which is actually a joint effort between the Germans and the Chinese. And the Germans have since divested of it, and this deals primarily with hot water heaters and so forth. It appeared on top of the Olympic Village at the Beijing Olympics. So this isn't just only a U.S. push, as you probably know. As well, the next slide talks about the International Energy Agency. Said that countries are spending $17 billion on renewable energy and energy efficiency research in the next 10 years. $56 billion was spent on nuclear energy research and $22 billion on fossil fuel research during the same period. So there is more that needs to be spent on clean tech, but if you looked at global conferences, just a small sampling, Singapore has International Energy Week and International Water Week. Copenhagen has the International Clean Energy Fair, and there are a number of different technologies out there. The U.S. isn't alone in trying to promote the clean tech wagon. So now we're going to look at Chinese imports coming to the United States, and this is where, after 24 minutes, we're going to move quite quickly to issues where you, your company, can move forward and protect yourselves, and what are the issues that you have. First, if there's Chinese technologies coming to the United States, Chinese clean tech that's coming to the United States and flooding the market at below-cost sales, or Chinese companies are using your own IP against you to enter the U.S. market, what do you do about it? So first is the trade remedy issue, which is Chinese products are coming into the United States. What do we do? Well, this slide here is an overview that shows, for those on the audio, the date it's a timeline from filing of a petition in an anti-dumping or countervailing duty case to issuance of an order and relief. The total time is somewhere between 10 to 14 months, depending on whether extensions are granted or not. There has been a recent case that was filed about photovoltaic cells into the United States, and in 2010, the imports of solar cells from China were valued about $1.5 billion. And there was a preliminary finding in December that the case should move forward, and that's now being considered by the Department of Commerce. I'm going to move from that and move straight into something called Section 421. If China is playing by all the right rules, there's something called Section 421, filing of the petition until you get relief 5.5 months, half the time in an anti-dumping case, so it gives effective relief very quickly, but there are some trade-offs compared to the anti-dumping. The 421 cases are unique. It's based off of the Global Safeguard Action, but it was a type of deal that was negotiated as part of China's WTO accession package, as part of joining the World Trade Organization. This clause will expire in December of 2016, so it's something that will go away. And this slide talks about all of the cases that have been filed to date dealing with Section 421. There were 6 cases that were filed under President Bush, 1 case under President Obama. President Bush did not give any relief in the 6 cases that were filed under his tenure. I was actually counsel and represented some of the Chinese respondents in 3 out of those 6. There is only 1 case filed under President Obama, and the president did grant relief, and it dealt with the tire industry. The petition was filed exactly 3 months after President Obama's inauguration, and relief was granted in September 2009, about 5 months later. In the 421 tires case, the next slide talks about the scope of what it includes, and the relief that was imposed was 35% duties added at the border. Then it dropped to 30% in the second year, and this year, the last year, it's 25%, and it will end in September of this year, just before the U.S. election. Politically, the USTR, Ron Kirk, the Office of the U.S. Trade Representative, he said when China came into the WTO, the U.S. negotiated the ability to impose remedies in situations just like this, and the administration did what's necessary to keep American jobs. And the USW president said, well, for far too long, workers across the country have been victimized by bad trade policies, and Obama made clear he's going to enforce American trade laws and help people like us. And that was followed up in April saying business is improving, production has increased, but employment has not only been maintained, but workers have been recalled to work. These positive results would not have been possible without 421 relief. If you look at what's coming up next, in the State of the Union address, President Obama specifically cited the tires case and said over 1,000 Americans are working today because we stopped a surge in Chinese tires. My question is, understanding the huge political issues between the United States and China, understanding that there's going to be a ramp-up in tensions as the elections draw nearer, and also understanding that there's a five and a half month window until this hits the president's desk, and this is actually a decision that goes all the way up to the president to decide whether or not to grant relief. Will an environmental case, because that's the next foreground, I think, in the battleground between the U.S. and China policy, will one be coming in roughly May 1? Because if so, if you calculate 5 to 5.5 months later, it's going to be hitting in mid-October the president's desk just prior to the election. So if you're someone out there who is looking to deal with clean tech and you're having some trouble either with IP or other issues, 421 may be an effective remedy for you, understanding the political environment, and I wouldn't be surprised if one of these cases came in. The word on the street, at least from those who understand the Washington scene and what's going on there, is that President Obama imposed relief here, but there was an informal message that went out and said, you know, I've given you this relief, but I don't want to see any other cases. I mean, there's no other way, it seems to me, to explain why more 421 cases have not been filed. And I'd be surprised if one did not come in the next couple of months. Now we're moving straight to the IP issues. Over time, from 1975, 80% of a company was made up of hard goods, and about 17% of a company, 20% of a company was made up with intellectual property or intangible assets. In 2005, that percentages has been turned directly upside down, so that 20% of a company is made up of tangible assets, brick and mortar, and about 80% is intangible assets. That leads us to what's called Section 337. And if you're a company who has your IP stolen and it's used against you to import goods into the United States, 337 could be a great remedy for you. It's extremely fast from the filing of the complaint until the remedy. You've got about 12 to 15 months. Compare that to patent litigation or other things in rocket dockets like the Eastern District of Virginia or in Texas, and Section 337 is much, much faster. Section 337 cases are argued before what's called the U.S. International Trade Commission, which is a quasi-judicial federal agency with broad investigative responsibilities in matters of trade. The ITC remedy is different than in a district court. In a U.S. district court before a judge, you get money judgments. You actually have to show how much, first you have to show that your patent, for instance, was infringed, and then you have to show to what extent your damages were. And in the ITC, they don't have that. Instead, what they do is they can exclude your competitors' products from the United States. And they set up a barrier. The ITC has jurisdiction throughout the United States, nationwide, what we call in rem jurisdiction, which deals over the product that's being imported. And they send a note directly to Customs Service, and the Customs Service will exclude the product from coming in at all. This has become the new rocket docket for cases. Apple, HP, GlaxoSmithKline, Beecham, even in biological suits, Zippo lighters for trademark disputes, and even individuals. There's a guy named Jeffrey Lee McCabe who made fulcrum tremolos on string musical instruments. He brought his own case as well to the ITC. And the one other thing to note is that the ITC cases are argued before knowledgeable administrative law judges, people who deal exclusively with IP issues. And I think the figure is that one every 6 years, one U.S. judge, one U.S. federal judge will hear an IP case every 6 years. But the ITC cases, the ITC administrative law judges hear those cases routinely every day. And I think that they're hearing perhaps upwards of 25% of all the cases that deal with intellectual property that are filed in the United States each year. in the legal issues, I'm looking at the time, and I want to keep moving, but there are 3 cases here that affect 337 cases and actually will push and funnel more cases to this particular jurisdiction. The first is eBay, where it was before the U.S. Supreme Court in 2006, and the decision in that case made it more difficult to obtain an injunction in district court. And there you look at Justice Kennedy's concurrence. In Kyocera, that was another key case in 2008. It overturned a long-standing ITC practice of downstream product relief, and it's giving more attention to limited and general exclusion orders, which are type of orders issued in the case. What that generally means is there's been a slight change in practice at the ITC, and people are actually being forced to name more defendants and more respondents at the same time, or more selectively pick who they're bringing cases against. And the last case, which was quite recent at the end of last year, was the Tian Rui case, which dealt with trade secret violators. And the ITC said that the Federal Circuit said that the ITC may impose relief when a trade secret violation occurs completely outside the United States, but the goods are imported in the U.S., and they applied what they called uniform federal common law. For those who are listening on audio only, I'm showing a set of slides here which gives you a sense of the trends for ITC cases. I compiled data dealing with cases which are filed at the ITC through 2008 and 2009, and this shows that there's been a trough. There was a peak of cases in '84, went down to a trough in the mid-'90s, and it's certainly on the rise now at the late 2000s and early 2010 through 12. The next slide shows maybe the top 6 or 7, top 6 countries who have filed cases. And then what I do is I isolate to show you the number of cases that were actually filed against China. And as you can see, there were, for those who are on the video, in the late 80s and early 90s, there were very little cases. Starting in about 95, 96, the cases started to trickle in, and by 2008, it had ramped up like a jet engine. It just immediately took off, and China is now dominating the 337 cases that are being filed at the ITC. And what I did is I took a look at the cases in China, and I tried to make a comparison to where China is going to be with IP cases to where Korea was in the same point in their own development years ago. I looked at cases in Korea from 77 to 2007 and found that there were 60 cases related to Korea. The 2 most important things to take away from this is that there was a sharp rise in cases in the last 5 years, and there's a sharp rise in foreign complaints. And I'll show you what I mean. The first is that in the case filings on the slide, in the period 2002 to 2007, were double the number than in the previous 2 5-year periods combined. So cases started to really increase in the last 5-year period for the Koreans. And you can also see the one thing that was quite interesting was in that same last 5-year period from 2002 to 2005, a large number of cases for the first time were actually filed by foreign complainants. And the conclusion seems to be that the Koreans themselves are starting to bring the cases. They've started to see that they don't need to be the defendants all the time. They can also be the complainants themselves. And I took that knowledge and that basis because Korea has moved from developing to developed country, has joined the OECD, and asked when will China make the same move to high-tech production, and will they be making the same sophisticated choices that the Koreans have been making. The cases that have been filed against Chinese companies have been mainly in the low-tech areas like ground fault circuit interrupters, nitrile rubber gloves, sweeteners, DVD players, and recorders. There have been some exceptions with semiconductor companies like the TSMC versus the SMIC. Those are the very large semiconductor manufacturers, one's from Taiwan and one is from China. And there is a move to higher tech products. I wrote an article that was published in Managing IP magazine, Will China Follow Korea to the ITC? And I looked at about 6 different factors. I said the first is innovation. Second is a long-term strategy. Third are what lessons have they learned from litigation. Fourth is how do the Chinese companies value intellectual property. Fifth is where within the company is IP being treated? Are the folks in charge of intellectual property and R&D having direct reports up to the leaders of the corporations in the CEO level and the C-band, or are they relegated to outside non-reporting positions. And third is how's new technology being treated. And in Korea, they have taken these models to heart, which is what you see oftentimes in U.S. companies, and they're employing it in their own companies. China, it hasn't happened yet, but I expect that it probably will. The question is how long it will take. The last point for you is that even if you're here in the United States, and this is an article from March 10th, just 3 days ago, in the Wall Street Journal, front page, you need to understand that the Chinese companies will try and come after trade secrets. Many other companies are dealing with trade secrets. I don't mean to just single out China, but that's what the press is reporting right now. And this particular case, which was filed by the FBI, marks the first time that U.S. officials have filed criminal espionage charges against a state-owned foreign company. And those charges allege that the Chinese government and company officials asked U.S. citizens to compile DuPont proprietary information used for the manufacturing of something called titanium dioxide. And it was a long-term, widespread effort to collect older information. It was hardly cutting-edge stuff, but if you're here in the United States, you still must be vigilant to try and protect trade secrets and try and protect your intellectual property, even if you haven't set foot in China, but you may be interested in future. So if you do decide to go to China, I haven't seen any questions. If there are any, of course, feel free to email them, and I'll try and look at the Q&A slide. But it looks like we're on time. The last thing is, how do you protect your IP if you're going to China into our Part 4? The first is, you got to understand that the United States, way back when, was a hotbed of the world's premier legal sanctuary for industrial pirates. Pat Choate, who was Ross Perot's running mate for president in the, I think, the late 80s, early 90s. This was after not Admiral Stockdale, but was somebody else. He actually wrote a book called Hot Property, The Stealing of Ideas in an Age of Globalization. And in that book, he gives something which I think is relevant to those who are thinking about entering China. He said, and this he's talking about the United States at the beginning of our nation building, he said, Hamilton and Congress wanted to rapidly industrialize the United States and to do so by whatever means necessary, a practice we now call nation building. America thus became, by national policy and legislative act, the world's premier legal sanctuary for industrial pirates. And he was talking, and I won't take the time to read the highlighted portions that I have from his book, Hot Property, but I commend page 30 to 31 to you. What he's saying here, and he gives an example of how the United States, and there was someone named Francis Cabot Lowell, who's a Boston entrepreneur, he went and he stole the plans for weaving cloth. And as Pat Choate says, he became a hero for bringing England's most valuable industrial secret to the United States. And at that point in time, he was welcomed in. Well, many view Chinese companies in the same way, to try and steal, to try and take any of the IP, and certainly in the clean tech field as the United States innovates. These slides, for those who are not on audio, are the typical slides you may see in psychology studies. For those on the video, what is it that you see here? Oftentimes people will look at this slide and they'll say, well, I see a vase and I see a face very clearly. The next slide is the one that looks like your IP. Many people will immediately see the vase and they see the face as well, the vase and the face, but they do not necessarily see the two Spanish-looking people, one on either side of the vase, and on the right-hand side of the picture, seeing someone come out of a doorway, and on the left-hand face, seeing the earrings, actually a bottle, a tequila bottle next to them. The issue here is, do you know what you have? And oftentimes, you may not recognize the intellectual property that your own company has, your own crown jewels, and it may make sense to try and go to someone who's an attorney or go to somebody who is well-versed in understanding the intellectual property so that you don't inadvertently give away something that you didn't recognize was gold. So the first thing is, understand what it is that you have. The second is, today, the stealing of ideas, is China now becoming the new premier legal sanctuary for industrial pirates? Again, this was in February in the New York Times. Ken Lieberthal, I studied with him at the University of Michigan 20 years ago. He has since gone to the White House. He's now at Brookings. His routine, and this is straight from the New York Times article, seems straight from a spy film. When he travels to China, and he is a key China scholar, The article said that he leaves his cell phone and laptop at home and instead brings loaner devices, which he erases before he leaves the United States, and he wipes clean the minute he returns. In China, he disables Bluetooth and Wi-Fi, never lets his phone out of his sight, and in meetings, not only turns off his phone, but removes the battery for fear his microphone could be turned on remotely. He connects to the Internet only through an encrypted, password-protected channel and copies and pastes his password from a USB thumb drive. He never types in a password directly because he said the Chinese are very good at installing keylogging software on your laptop. And he's not alone. Folks have said, if only the top counterintelligence official at the Office of the Director of National Intelligence has said if a company has a significant IP that the Chinese and Russians are interested in, you go over there with the mobile devices, your device will get penetrated. So consider whether or not, if you're leaving the United States to go to China, you should have as company policy clean devices that are sent over. And certainly if you're in areas that deal with export control and IPR-related controls, you're aware of non-export-related issues and you can't bring a laptop with you, but that's something to be aware of. Question, China and IP, is it time to believe? I wrote an article for the Washington Legal Foundation called The Legal Pulse. Qian Lipu, who was the commissioner of China's IP office, declared in December 2010, the Wall Street Journal opinion article that China is serious about protecting IP rights. And Commerce Secretary at the time, Gary Locke, who's now the U.S. ambassador to China, the next month publicly lamented China's lax IP protection and enforcement. And the question is it really time to believe that China is doing better? Well, Commissioner Lipu's declaration was nothing new. In 2006, he told China's state-run website that more IP protection helps Chinese companies and promotes innovation. But within a few short years of that, there was lax enforcement, and that escalated to a trade dispute that both the U.S. and China claimed victory in January 2009. This slide gives the front page from the report of the panel. It was not appealed to the appellate body, and it was left as it is. Issues are heating up with the coming presidential election. Remember where we were in the future, and I think that you're going to see a lot certainly in the realm of clean tech as well as in the sources for clean tech. Again, this is cutting edge as of yesterday and today. March 12th, the U.S., Japan, and the European Union filed a request for consultations with China at the WTO concerning rare earth metals, and other issues that are going to probably receive attention in the coming months are auto parts, cars, and other issues that deal with clean tech. And also on March 13th, the President signed it retroactively to revise the trade laws to allow for filing of anti-subsidy cases. There are some improvements that do need to be noted. For instance, in March of 2011, the Journal, Wall Street Journal, reported that there were software makers, Microsoft, Adobe, and Autodesk. They settled some copyright infringement suits against a mid-sized Chinese steel structure engineering company. But while it's good on its face, it's also important to put that in perspective. The settlement was just shy of U.S. $200,000, and that was split three ways. So although supposedly this does not include undisclosed financial damages that weren't reported in the paper, the use of pirated software is still widely reported and is still pretty rampant. That's something to take into account when you're going over. So the question is your company going over? If you haven't made the decision yet, should you establish operations in China? If that's a question for you, some of the things you should think about are, well, many companies decide to establish commercial presence in China despite the IPR theft for various company-specific reasons. It could be the size of the relevant market or the cost advantages associated with opening a factory in that location. Some factors include cheaper employment, less environmental restrictions, cost of raw materials, and so forth. For them, the issue is not whether to manufacture, but rather how to do so in a manner that adequately protects IPR. For others, this balancing weighs against going into China. There's a company in Gaithersburg, Maryland, that operates in perhaps 50 countries around the world. Bobby Patton of Patton Electronics has chosen not to go into China. In fact, he's removed his products from China because he received, as an example, a device for a warranty replacement that was not his parts. It was in his outside container from Patton Electronics, but the inside guts weren't his, and things were getting ripped off too rampantly for him. But for some industries, for instance mining, econometric modeling shows that there's no positive association between IPR protection and enforcement. And that, if you think about it, that seems to make sense, because whether to open a copper mine should not be based on whether a country has strong IPR rules or enforcement, but more on issues like global demand for copper and location of those deposits, and you go where those deposits are. So I think your industry will affect, and your particular company will affect whether you want to source from there. There are other places that can also be just as effective. I'm not promoting Singapore or Hong Kong or other regions, but there are places that say, I wrote a report that was co-sponsored by jointly funded by the U.S. Patent and Trademark Office and the International Intellectual Property Institute, which is a think tank in Washington. And this paper was presented on the first day of the annual public forum of the World Trade Organization in Geneva in September of 2010. And it looked at a number of things. It asked, how do you stimulate innovation, among other things. It looked at tax incentives, grants, research centerings, clustering of IP resources, a strong intellectual property office, ready financing, and rule of law, effective rule of law. And we had termed it the Singapore model because of how Singapore tried to structure everything around it to attract IP centers. And Hong Kong and Singapore have been quite effective in doing that. So if China gives you some concerns, there are other areas that could be your regional hubs just as easily. The other thing, which is now a new trend, is be sure to register and protect your IP in China. Because even if you don't go to China now or plan to in the near future, you need to register and protect your rights because others in China will squat on those rights. China is a first-to-file system. You're also seeing this in some other countries, like in Korea, for instance. And it could be costly for you later if you then need to negotiate with the person who's taken your company logo, and you have to negotiate for that back. Registering in the United States also helps with what we call statutory remedies, which means you don't have to prove that there's been a certain amount of damage to you in each case. Instead, by law, if you've registered, you're entitled to a certain amount or a fixed sum for every day or for every violation. And that could help to a great extent in certainly leverage for negotiations and certainly in collecting as well and improving your damages. If you do go and you are already there, you should consider segmenting your production process. What this means is that if you're manufacturing in China, you could produce only elements of a product in the weak IPR environment. And if the example is, for instance, there was Firestone Tire. The general counsel and I sat on a panel in Chicago in October 2006. And he was talking about how Firestone maintained their secret sauce for their tire production back in the United States. And they had separate factories in different locations in China, each which produced a discrete segment of the tire. And those separate factories had no idea that the other one existed. So they would produce part A of the tire, for instance, in Shenzhen, and then they would produce part B of the tire in, say, Shanghai. And both of those would be sent down to be assembled in the United States and added with the protective sealant, for instance, that was a trade secret that the company didn't want to disclose. By segmenting your production, you can still take advantage of cost of production and other things that are important to you, and at the same time maintain your intellectual property, which could be a big deal. You should also keep apprised of developing trends which Chinese companies are using against United States companies and other companies in general. And oftentimes it's used in retaliation. If you're a consumer products company or a company that sells to big box retailers like Walmart or Sam's Club or something like that, you should understand one of these trends. For instance, in China, many are downloading patent applications filed in the United States and elsewhere, literally copying them, and then filing for Chinese patent based on the blatantly copied prior art. And what they're doing is this is in retaliation for U.S. suits that are brought under Section 337 that we talked about, or some other things, for instance. The U.S. firms will be able to invalidate the patent oftentimes, and they're going to get their rights back, but they have to file for them, and they have to engage counsel abroad and understand what the process is. And the problem here is if you're trying to seek production to get into a Walmart on a Black Friday in November, you have to understand that the orders are going to come in, and you need to start your own production and your own shipping lines as far back as perhaps March or February in order to fulfill those orders in time. If there's a cloud on your intellectual property right and your competitor has filed and actually obtained a patent and you haven't been watching for that, abroad, and they essentially have can forestall you until you can unwind what has been done, they will essentially be able to prevent you from actually producing that product in that buying season, even though you will be able to successfully complete your rights in future. And this is something that I understand has been happening to folks overseas, and have talked specifically with people. So you need to keep apprised of what's going on, and also have ties into, I think, knowledgeable counsel who can help to forestall that or be proactive in policies for you. So key considerations when engaging China: number one, make the decision. Give serious thought about whether you want to make the leap eastward and go there. Second, cultural dynamics are going to matter. If you are going to go, spend time learning the unique characteristics of doing business in China, such as understanding that whom you know is going to be critical. The third issue is proceed with caution. Build relationships with potential partners. Conduct your due diligence. Identify those who know China and can help you achieve your goals. And the fourth is protect yourself. Of course, protect your IP, but understand that managing a relationship based strictly on legal documents could be a mistake. While getting in writing helps, personal relationships are going to matter. So think about what can go wrong as well, and consider your exit strategy before you go to China. Arbitration may not always be possible for all disputes, because arbitration means that the parties must agree to arbitrate the dispute. And when you're enforcing IP rights against people who are counterfeiting or trademarking violators where there is no contract, often you have to go to the local courts, and arbitration won't be an option for you. And that could be expensive, or you could be before a local court that is less receptive to a foreign body. China's getting better on that, but it's not yet where it entirely needs to be, according to many of the business contacts I speak with. So how do you deal with them? Sometimes you need to be creative. First, dealing with counterfeiters, the Technical Supervision Bureau in China has the authority and ability to examine documents, conduct investigations, and they can also conduct raids and do so quickly. For instance, the Shanghai TSB, Technical Supervision Bureau, can make a raid decision in several days, as opposed to 3 to 6 months to navigate a system to a formal decision. And raids can shut down the competitors and be quite helpful for you. You could also do that through the U.S. consulate in Shanghai, through the U.S. AmCham, and some of your other sources of supply. You can sources of knowledge-based supply. You can also deal with trademark violations through the State Administration of Industry and Commerce, or the AIC. It has many of the same powers in the trademark context that the TSB has against counterfeits in order of seizing products. But you can also be creative, and there was an article that I saw in an American Bar Association publication that said, look, why don't you call the fire department? You can look at child labor, safety, health, fire codes, and although these departments may not have the power to seize the counterfeit products, there may be an advantage to you in having them conduct a surprise inspection, which disrupts their production line at the factory and could also result in penalties for non-IP issues. So if counterfeits are also found during the surprise visit, a trademark or copyright owner may be in a better position to lodge a complaint with the relevant administrative body that does have control. So that's another suggestion when you're actually in China. So the final conclusions is 4. Number 1, read the tea leaves. Larger political dynamics do affect the U.S.-China relationship, and it will impact your business. You should take advantage of those. If you spot where people have been, you can identify, I think, where the next cases are going to be, where the next funding programs will be from the United States, and where the best pressure points will be for your business. Second is protect your IP and your R&D. Think about travel abroad policies, compartmentalize your production, be proactive in patent enforcement, register your trademarks and copyrights with Global Watch Services in whether your own counsel or others. I'm more than happy to help. Execute your NDAs, vet your licensing requests, and so forth. The third is understand that you're in China. Negotiation is key. Politics are important, particularly if you can call on a powerful trade association, embassy official, whether it's U.S. or Chinese, local government contact to act as a pressure point for what is right. That's going to be important. And the fourth is legal proceedings, including arbitration, to help your negotiations sometimes, but they may not be a total fix. You need to be prepared to compromise, and you also need to be proactive to actively seek to avoid disputes. That's the presentation. Our contact information is here. Again, my mobile number is 202-262-1197. My email is akoff, A-K-O-F-F, 2 F's in Frank, at WTPLAW.com. and we're also on the web at www.wtplaw.com. Happy to take any questions that you may have, and thank you for letting me present. Apologize that we got started a little bit late due to some technical difficulties.
Well, thank you very much, Alex, for your presentation. And with that, Barbara, if we could probably open up for about 10 minutes of questions or so if there's anybody who would like to ask a question of Alex.
Thank you. Once again, to ask a question, to press star, then 1. Glenn Roberts, you may ask your question.
Hey, Alex. Great presentation, and I'm with the commercial service out here in California, and of course, China's just across the waters from us, and we have quite a few potential buyers coming through. One of the strategies I've seen to effectively kind of control it, you touched on a little bit today, and I'd like to find out from you how effective is the strategy in regards to trademark and branding. Is it like the first line of defense to protect your IP as a strong brand and a trademark?
Did you have more to the question, Glenn, or was that should I focus on that one?
No, not much more to the question. A little bit of the background is then, some of the IP technology is well over the head of the people who are enforcing such technologies. And I think it's kind of easier for our companies to develop a strong branding strategy. And if you can elaborate on that and let me know if that's a good strategy and a good first line of defense for protecting IP.
Yeah, it's a great question. I also serve as the vice chair of the Maryland, D.C. District Export Council, the Maryland, D.C. DEC. So I appreciate all the great work the commercial service is doing. And Undersecretary Sanchez was in Maryland yesterday at a White House briefing and gave a strong presentation, and we had a number of discussions on these and other issues. And Ambassador Chuck Ford also came to Maryland, I think, about 3 weeks ago, attended our DEC meeting, and it was great to see the support of the commercial service. I think you guys do phenomenal work for companies out there. If companies are not taking advantage who are listening to this of the gold key services that the commercial service offers or the vetting processes, you should be. To answer your question, Glenn, I was in Korea, and this will relate to China, in February, and I was with the commercial service, and I was talking with people in that office, and they said, please, please, please ensure that companies will go forward and protect their trademarks, protect their branding, protect their rights, because Korea, like China, is a first-to-file system. And what's interesting in Korea is the government officials, it was reported to us, and I was doing this through a study as well that was sponsored by the U.S. Patent and Trademark Office to look at U.S. technical assistance and how that helps U.S. exporters sell their goods overseas. What was reported to us is that it's interesting, the strong technical assistance programs that were employed in Korea in the 60s and 70s and throughout, as well as through the UNDP, have educated the Koreans, and they're full on board. The Koreans are now proselytizing to the Chinese, and what the Koreans reported back through those meetings, which were at the embassy, is that although in many first-to-file systems, people can go in and register rights and squat on those rights, in China, they're actually doing it uniformly and as a practice. So in Korea, before someone has entered the market, there may be less of a risk to actually set up your branding strategy and to register your trademark and to register your intellectual property rights in those foreign markets until you actually go in. In China, the reports that are coming in is that the Chinese are actively going outside their borders, identifying some neat companies that have no intention of going to China for another 5 to 10 years and actually registering those rights today because they know that the folks will be coming to China in future. So I think it's extremely important for a trademark and branding as a first line of defense to immediately register those rights in China as abroad because it's such a huge market. And although it may be an expensive prospect in the class of service, if you identify what could be your most profitable in future, that would really be quite helpful. And another example is Under Armour, which is based here out of Baltimore. When they had limited budget, instead of pursuing patent protection or some other intellectual property rights protection to try and protect their wicking technology and other things for their clothing, they instead drove all of their revenue and early development into the trademarking and global brand building and recognition. And I think that's paid off quite well for them. It depends, I think, on the market. It depends on the company. But for many companies, I think it would be Square front and center, consumer goods really being that front and center one. Does that answer your question?
It certainly does, and it's a great confirmation. And then what is the average cost, I mean, maybe a high ballpark side to register your trademark?
It's not a huge cost in general. There are two components to it, and I have the figures. Our firm has standard flat rates. Other firms do as well, I'm sure. I don't have them in front of me. But there are two things. The response comes in two components. The first is you're going to want to do U.S. trademark registration as well as what we call third-party watch services. But I can't talk about other firms, but I can tell from our experience, we monitor so many trademarks that the watch services, the third-party services, give us a discount, like a 6% discount, which get passed on. And I think it's in the realm of less than $1,000 or maybe $350 to $500 for multiple watch services. So your company would then say, could you please look at our trademark as in this class of service for this Internet extension and domain name, and they will go out and monitor and produce reports that get sent to your lawyer or directly to you on a weekly basis to say, this particular trademark has been filed in this other country, in this other jurisdiction, this web address has been filed, which is confusingly similar with yours, so that you're out there actively monitoring and trying to protect your mark, which I think is important. So that's the first component, which is relatively nominal, I think, in a grand scheme. The second, which is more dicey, and I won't give you a great answer for that, I apologize, is how expensive will it be? That depends on where you're going to decide your key markets are, and that's a very company-specific issue. If you say that I need to protect myself in Korea, in China, in the following Asian countries, or if I want to go to some of the BRIC countries, wherever it may be, each one will have their own separate national fee because there's no general international-wide trademark that you apply for. You actually have to go into each country and specifically reserve your rights, and you have to do it by class of service, meaning I'm going to do something like a T-shirt as opposed to a software technology, and you can register in each of those classes. And there you need to decide carefully and cost-effectively where am I going to get the biggest bang for my buck in terms of protection. Again, it's not very expensive in the grand scheme if you're going to try and do a development rollout and you're going to enter another foreign market and you have a number of different things at your disposal that the USIACs can assist you with, as well as Ex-Im Bank financing. Many people who enter those foreign markets are scared by it, but if you actually do some export control, if you do some export work and you focus on how you're going to deal with exports, the benefits driven to your bottom line will far exceed or should far exceed the cost of registering your trademarks.
Correct, and thank you so much.
Yeah.
All right. Right, thank you very much. I think that's about all the time we have for questions today, but thank you again to Alex, and thank you for everyone for listening. And just to let you know, of course, feel free to follow up with Alex additionally if you have any questions. And a copy of this webinar will be posted on our website, www.stopfakes.gov, www.stopfakes.gov, if you want to listen to it or review any other parts of the webinar later. Thank you again, and have a good day. Thank you.
This concludes your conference call. You may now disconnect.